Hello guys. So this video I will start from special status to state of Jammu and Kashmir. So this is not an updated version, that's why in this book it's written that Jammu and Kashmir has a special status, but now since we know that this special status is abrogated, Article 370 is scrapped. So now the state of Jammu and Kashmir not holds a special status, and now as per Article 371 some sort of special provisions are only provided to the northeastern states, to those northeastern border states, not to J&K. So let's read it what it's given, but remember this is not an updated version. State is part of Indian Union as defined under Article 1, read with first schedule of Indian Constitution, but under Article 370 it enjoys a special status. State has its own constitution. Now that constitution and a special Ranbir code it had, IPC for the whole India, and for Jammu and Kashmir before the scrapping of Article 370 it had a Ranbir code. The state has its own constitution drafted by its constituent assembly, so everything was different: own constitution, own flag, own citizenship of J&K, nothing of India, no law which was made for the whole of India was applicable in J&K without the permission of its constituent assembly. So debates were held in both the houses of parliament for converting a bill into a law for the whole of the country, but for Jammu and Kashmir in its constituent assembly another sort of debates and discussions took place that whether this law would or would not be implemented in J&K. So that was how it happened before, but now since this state is merged into the mainstream, so now there is no such separate constitution or something like that. State is governed under this constitution. Article 370 empowers president to define constitutional relationship of that state in terms of provisions of Indian constitution. So as per Article 370, president had the power that constitutional, that what would be the relationship of J&K in terms to the provisions that are mentioned in Indian constitution, what would be its relationship, that was allowed by the constitution to the president to decide. On October 26, 1947, Maharaj of Jammu Kashmir signed instrument of accession for J&K to accede to Indian dominion, because at that time the Pakistan people had attacked on J&K because they wanted a portion of it to be occupied and merged into Pakistan. So the Pakistan army had attacked that time, and Maharaj of Jammu and Kashmir earlier wanted to create a separate country of his own, but due to this attack he was not able to manage the situation, and for that he asked the help of the Prime Minister of India at that time, who was Pandit Jawaharlal Nehru, and in exchange of the help of Indian army that Jawaharlal Nehru would be providing J&K at that time, he demanded that Jammu and Kashmir should be merged into India, and for that merging this instrument of accession was signed. So each and every state, when it got merged in India, it signed this instrument of accession. Article 370 further states that power of Parliament to make laws for said state shall be limited to those matters in Union list and concurrent list which in consultation with government of state are declared by President to correspond to matters specified in instrument of accession governing the accession of state to Dominion of India as matters with respect to which the Dominion legislature may make laws for that state, and such matters in the said list as with concurrence of government of state the president may by order specify. That means Article 370 gives the parliament, gives power of parliament to make laws for this state, but the limitation is that for union and concurrent list obviously the parliament can make the matters, or the central government can make laws for the matters which are in union and concurrent lists, but the government of the state need to be consulted, the legislative assembly, legislature of JNK should be consulted, and if legislature after debates and if state government gives permission that yeah, this law of India can be applied to JNK as well, then only it could be applied to that state. So these all things are the earlier times before scrapping of Article 370. Remember this thing. Now, adult suffrage, that means vote for each and every person who is above a certain age limit which is set, that is 18 years of age, right? Article 326. So please remember, these articles of Indian Constitution are very important. Which article gives voting rights to Indians? That is Article 326. Please remember, Article 326 confers on citizens of India right to vote in general elections, to House of People and to legislative assemblies of states, the state government, the central government, the mayor and municipal corporation elections that are held. In all these elections, we can vote. Every citizen who is not less than 18 years of age, means 18 and 18 plus people, can give the vote, right? And earlier this age was set to be 21 years, but then it get reduced to 18 by 61st, that is 61st amendment of Indian Constitution 1988. You may not remember the year, but you have to remember which number amendment, what change came about. So election age, the right to vote age earlier was 21, reduced to 18 by which Constitution amendment 61st. Then otherwise not disqualified under Constitution or any other law on grounds of unsoundness of mind, non-residence, crime, corrupt, illegal practice, shall be entitled to be registered as a voter at any such election. As we know, we need to first register ourselves with the election commission, and then that body will issue us a voter card, and with that voter card only the person whose name and all such photo and all such details are mentioned, he or she can only give the vote by showing that card to the authorities which are present at the polling booths at that time. So we need to register. So any person who is above 18 or 18 plus, any person who is 18 or 18 plus age and who is not deliberately disqualified by any law at practice at that time, who is not unsound and who is not a citizen of India, जो citizen नहीं है, तो citizens को ही सिर्फ राइट है जो यहाँ रहते हैं, जो यहाँ के citizenship जिनके पास नहीं है वो वोट नहीं दे सकते. क्रिमिनल है, करप्ट या इलीगल प्रैक्टिस करी है तो वो डिसक्वालिफाइड बाय लॉ है टू गिव वोट्स. There is one general electoral roll for every territorial constituency as stated in Article 325 for election to either House of Parliament or to House or Houses of State Legislature. That means we have some booth numbers. If you have heard in your daily lives, we have some booth numbers. There are 80 seats in my state, Uttar Pradesh, if I talk about. So such like that, some on the basis of territory, whatever the boundary and whatever the type of big or small state it is divided into various booths or electoral rolls. Some seats are provided, so based upon that, and that is done as per Article 325. So Article 325 gives various electoral roles depending upon the territory, and Article 326 gives the voting rights. This article specifies that no person shall be ineligible for inclusion to electoral roll on grounds only of religion, race, caste, sex or any of them. That means there will not be any discrimination on the basis of religion, race, caste, gender. ऐसा कोई भी discrimination नहीं होगा. And if he is eligible by law, if he is not deliberately disqualified by any law, then he will be definitely included in the electoral roll. That means in the list of the eligible voters. Now, Afto versus Stare, the doctrine of basic structure propounded by Supreme Court in Keshwanand Bharati case, and in Cohaltal of Tamil Nadu Supreme Court held that object behind Article 31B was to remove difficulties and not to obliterate rights guaranteed under Part 3 and judicial review. Part 3 is fundamental rights, right? Thus, every law passed and amendment made must not destroy the basic structure. Thus, any law added to 9th schedule may be reviewed by the courts. So, any law which government puts deliberately under 9th schedule, 9th schedule में वो laws हैं जिनको आप review नहीं कर सकते, basically वही laws डाले जाते हैं. तो अगर गवर्नमेंट चाहती है कि ये चीज़ जुडिशियल रिव्यू के पास ना जाए, उसको थोड़ा डाउट है अपने लॉ पे और वो चाहती है कि जुडिशियल रिव्यू पे ना जाए, तो वो 9th शेड्यूल में डाल देते हैं. बट इन दीज केसेस सुप्रीम कोर्ट हैड मेड इट क्लियर दैट इवन इफ इट इज़ इन द 9th शेड्यूल बट इट कैन बी reviewed still. Articles 330-332 provide for reservation of seats for SCs and STs in House of People, Legislative Assemblies respectively. That means Article 330 is reservation of seats for SCs and STs in House of People. Article 332 is reservation for SCs and STs in Legislative Assemblies. So these articles, wherever they are coming, make a note of it and learn them all. Article 331 provides for representation of members of Anglo-Indian community in the House of People. Now this reservation is also scrapped. You may be updated. Keep updating your knowledge. In case of Indira Nehru Gandhi versus Raj Narayan, popularly known as election case, wherever these landmark case names come, you have to learn them also. Indira Nehru Gandhi Raj Narayan, known as election case, right to free and fair elections, has been declared to constitute the basic structure. That means the government or the election commission has right to conduct free and fair elections. So what is free and fair elections? Everybody will get a chance to vote and it will be free to all. Okay. Then single citizenship. Constitution of India provides single citizenship to its citizens. Means if a person is registered as a citizen of India, he gets a citizenship of India. Passport को माना जाता है citizenship. या अगर यहाँ पे birth है, by birth और by registration, if you are registered that I want to acquire the citizenship of India, so you can acquire by registration. And if you are born in India, then obviously you are its citizen only. So if a person registers himself to get the citizenship of India, then he cannot register to get citizenship of any other country. He can, but as soon as he registers at the citizenship of another country, he will automatically lose India's citizenship, because Indian constitution allows single citizenship. एक ही कंट्री की citizenship you can hold, not more than one. Part 2 contains provisions regarding citizenship at commencement of constitution and other matters. Citizenship Act 1955. Now this is a very important thing, because something related to this, CAA, NRC, was a hotly debated topic few months back. In December last year, in January this year, and all, it was filled with this only. So it's an hotly debated topic. You need to know more about it. You must know, actually, you should search about it. And otherwise, Citizenship Act 1955 provides that how citizenship can be acquired by various people. If they are born in India, if they मतलब पेरेंट्स कहीं और के थे बट दे हैड देन नाउ सेटल्ड इन इंडिया, तो अब आप बॉर्न हुए हो यहाँ पर, और बाय रजिस्ट्रेशन. Act provides for citizenship by naturalization and by incorporation of territory. Means if a certain territory by war, if India wins that area and that territory is also now merged into the Indian subcontinent, तब भी वहाँ के जो लोग होंगे उनको वो इंडिया की citizenship मिल जाएगी. Citizens of India enjoy political and civil rights enshrined under Constitution, such as right to vote, contest elections, hold high offices, such as that of a president. Means कोई भी बंदा, regardless of any sort of discrimination, he can stand and run an election, right? ये पढ़ा था हमने. वाइस प्रेसिडेंट, गवर्नर, जजेस कुछ भी बन सकता है, वो कोई भी जॉब ले सकता है, कोई भी ट्रेड, प्रोफेशन, कोई भी रिलीजन फॉलो कर सकता है। राइट टू वोट, राइट टू कंटेस्ट इलेक्शन, सारे लिबर्टी एंड फ्रीडम उसको प्रोवाइड किए गए हैं बाय कॉन्स्टिट्यूशन। नो सिटीजन कैन बी डिनाइड एम्प्लॉयमेंट इन एनी स्टेट ऑन ग्राउंड्स ऑफ बीइंग नॉन रेजिडेंट ऑफ दैट स्टेट। इफ़ यू आर नॉट a citizen, or if you do not have the domicile, or if you are not the resident of MP, that doesn't mean you can't be provided a job in MP. If you have migrated and you want a job and now you have settled in Madhya Pradesh, in any city of Madhya Pradesh, then you will be, if you apply, you will be granted the job. You will not be excused or rejected on the basis of that you don't have the domicile of this state. Independent judiciary, as we all know, all the three organs of government that we are having, they are independent of each other, they work independently. So as judiciary, independent of legislature and executive. Another notable feature is its provisions which uphold the independence of judiciary from influence of other organs. Other organs are legislature and executive. Judiciary functions in accordance with set principles. Every body functions according to the provisions or principles which are stated in our constitution, because that's the supreme lawmaking body in our country. This topic has been dealt in preceding chapters. Schedules to Constitution, all the schedules are mentioned. What is all in that schedule, that is also mentioned. Let's go a quick reading and then this chapter will be done. 12 schedules are in Constitution of India. Provide necessary administrative details that how the organs of government would function. They can be amended. First schedule is the list of states and union territories in the Indian subcontinent. Second is emoluments, allowances, privileges of president, governor, speaker. जो भी हाई रैंक ऑफिसर्स हैं उनके क्या privileges हैं, उनको क्या allowances दिए जाते हैं, क्या benefits दिए जाते हैं that are associated with that post. All such things. Now you see the high rank offices: President, Governor, Speaker, Deputy Speaker, Chairman, Deputy Chairman of Council of States, Speaker, Deputy Speaker of Legislative Assembly, Chairman, Deputy Chairman of Legislative Council of State, Judges of Supreme Court, High Court, Comptroller and Auditor General of India, that is CAG. This thing in short is known as CAG. Third schedule, the oath and affirmation. इस ऑफिस, इस पोस्ट के लिए कौन ओथ ले सकता है, कौन उसको ओथ दिलाता है, what all has to be mentioned in that oath, who will confer the oath, that all. Fourth is allocation of seats, that how the seats will be distributed in Council of States. Fifth is provisions regarding administration, control of scheduled areas and scheduled tribes, those नॉर्थ ईस्टर्न स्टेट्स बेसिकली. वहाँ पर किस तरीके से उनको एफिशिएंट एडमिनिस्ट्रेशन के लिए कंट्रोल किया जाएगा. एज आई टोल्ड यू, देयर इज़ आर्टिकल 371 विच प्रोवाइड्स सम स्पेशल स्टेटस टू दोज नॉर्थ ईस्टर्न स्टेट्स. तो किस तरीके से उनके क्या प्रोविजंस हैं, दैट ऑल. Sixth is regarding administration of tribal areas in Assam, Meghalaya, Mizoram. Seventh, the subject matters, the three lists is mentioned in 7th schedule. Eighth is the list of languages, 22 official languages we have. Ninth is validation of acts and regulations. As I told you, 9th schedule में जो add होता है तो वो उसको review नहीं किया जा सकता, but now Supreme Court has said that everything can be reviewed by judiciary. 10th is provisions as to disqualification on grounds of defection. This is popularly known as anti-defection law. If a person just before the election changes or means many a times he keeps changing on his party in which he was, then उसके खिलाफ ये defection law लग जाएगा. तो इसके बारे में आप खुद पढ़िए, सर्च करिए what is anti-defection law. 11th is pass authority responsibilities of panchayats, that is पंचायत के बारे में 11th में है. 12th is pass authority responsibilities of municipalities. Panchayats are basically at the rural level in villages and all, and municipalities or municipal corporations is at the urban level, that means जो mayors होते हैं, that thing. So that's done. And also you need to remember what these broad idea or a brief idea of what these 12 schedules are all about. So here this chapter is done.